Hi, everybody. Thanks so much for joining us today on our presentation on transatlantic data flows post Schrems 2. So we're going to be focusing on the transfer of data from Europe to the United States and around the world. I'm Brett Cohen. I'm a partner in the privacy and cybersecurity practice at the law firm Hogan Lovells based in Washington. And I'm pleased to be here today with Alexandra Ross, Director of Global Privacy and Data Security Council at Autodesk, and Dr. Gabriela Zamfir Fortuna, Senior Counsel for Global Privacy at the Future of Privacy Forum. So jumping right into it, we're going to get into the complex world of international data transfers. And we're going to start with a little background on where we are today with transatlantic data flows. So I'm going to take it a little ways back to Edward Snowden. If you'll recall, back in 2013 is when he revealed to the world what the U.S. intelligence community was doing with access to data, and this actually caused a fair amount of churn and consternation in the privacy world due to U.S. government access to data of Europeans. And so there was a significant back and forth discussion. We throw a quote up here from the European Commission, where there's been this, I would say, long simmering sort of debate or discussion about the appropriate privacy framework for commercial access to data, whether in Europe or in the United States. There are different privacy standards. And this just added some fuel to the fire, with European bodies taking note of this and saying, wait a second, we're talking about different layers of privacy protection. Perhaps personal information of Europeans isn't as safe in the United States because it isn't subject to as many due process protections when the U.S. government seeks to access the information for intelligence purposes. So this led to a number of other discussions and debates. And what's popping up here is a picture of the Court of Justice of the EU, which is the highest court to interpret European constitutional and privacy rights. And we had this framework called the US-EU Safe Harbor. Some of you may remember this. Where under European law, there is a baseline requirement that to transfer personal information outside of Europe, dating back 20 plus years or so, that it needs to go to a jurisdiction that has appropriate privacy protections. The US and the European Union negotiated this safe harbor framework through which US companies would certify to treat information with certain privacy protections and would enable transfers from Europe to the US with what the European authorities considered appropriate privacy protections. Well, after the Snowden revelations, due to this feature or factor of US government access to data, the Court of Justice of the EU overruled or invalidated safe harbor. It said it wasn't appropriately considered to cover transfers from Europe to the United States. And this left the 5,000 or so US companies who were working under safe harbor in a lurch. What do we do? And so for those of you in this world, a number of companies immediately went to go enact what we call the standard contractual clauses, which was a set of pre-set contractual clauses that were pre-approved by the European Commission to serve a similar function, to provide appropriate privacy protections for information. Except where the issues with data transfers were fundamentally with what the US government was doing with access to information, there was some question of whether a different mechanism would even move the needle at all from a legal perspective in Europe. And we throw a quote in here from the Irish Data Protection Authority, who was evaluating the case, that cast doubt on the use of the standard contractual clauses even back then. So what happened after that? The US and European Commission negotiated a new framework to replace Safe Harbor called Privacy Shield. Some of you may be familiar with this, which took effect about a year or so later. And companies could once again sign up to this framework make privacy commitments and lawfully import personal information from Europe. However, in comes Max Schrems, which is a picture of him. So the story goes is he was in a law school class, heard someone from a US tech company talk about the collection and use of European personal information, didn't think that it conformed to European standards, and that set him off on his series of lawsuits to challenge European to US data transfers. And hence the name of the Schrems Schrems series of cases. It goes a little further back because he was the first challenger. So the invalidation of Safe Harbor was Schrems 1. Now we're challenging Privacy Shield, and he has to go up to the Irish Data Protection Commissioner again, goes back to the Court of Justice of the EU, who invalidates Privacy Shield. That's a lot of legal background. The whole point of this is there's lots of moving parts going on, and it's really this sort of complex legal environment that's really leaving a lot of companies in a lurch. So we'll get a little more practical going forward. There's Privacy Shield going away. So what we wanted to do was really focus on what the court said in Schrems 2, which will help you focus on what you have to do in response to it. And what the court said is, recall that we're talking about this baseline level of protection that companies who are handling European data or data that's subject to the European General Data Protection Regulation, or GDPR, have to, when transferring information to a jurisdiction outside of Europe, have to use a data transfer mechanism. Currently, the primary means are these standard contractual clauses, since Privacy Shield is no longer and Safe Harbor are no longer effective. So what the court said when striking down Privacy Shield was that data transfer mechanisms must afford essentially equivalent privacy protections to EU residents, taking into account whether the transfer is lawful under GDPR, and the ability for law enforcement to access data in that third country. And that is the key piece that has caused a lot of upheaval in what companies have been doing since then. This decision, by the way, came down last summer. And so there's been this state of uncertainty with what to do about transatlantic data transfers since last summer. The main conclusion of the court is that Privacy Shield was immediately no longer lawful for EU personal data transfers to the US. Going on to this piece focusing on US law enforcement access to data, the court concluded that US surveillance, particularly national security surveillance, did not limit data collection to that which is strictly necessary. And in particular, surveillance under the Foreign Intelligence Surveillance Act, Section 702, as well as surveillance occurring under Executive Order 12333, which is an order that gives the US government certain authorities to surveil communications or other networks outside of the United States. And then separately, the court concluded that EU data subjects don't have actionable redress before US courts, particularly in these national security and foreign intelligence cases. Now, this was a pretty severe implication because we're not easily changing US national security surveillance laws. And the other really key piece of this is a decision by the Court of Justice of the EU, the highest court interpreting European constitutional law. So at the end of the day, if this is what the European Charter or its constitution says, it's going to be very difficult to craft a solution that try and accommodates or meets that standard. The real sort of key piece to take away for what companies should do next from this opinion is what it said about the standard contractual clauses, again, which are these model contracts that a number of companies entered into to approximate Privacy Shield or for transfers to jurisdictions outside of the United States to meet the European privacy standard. The court said that they continue to be lawful, but only if the data exporter, which is the company that is transferring GDPR personal information to a country outside of Europe, undertakes a case-by-case assessment that the standard contractual clauses can be complied with in the receiving country such that privacy rights are equivalent to the EU. So again, that means evaluating national security surveillance in all countries that are receiving data, and then separately taking into account, and this is the real saving grace, which we're going to talk about a bit, or at least so far, the saving grace, taking into account supplementary measures that can help meet this privacy standard. And we'll talk about that in a little bit. So the sort of the takeaways for this that we took away from this opinion, the bottom lines are that standard contractual clauses for the time being continued to be lawful for EU personal data transfers to the US and other countries that weren't deemed to be have adequate privacy protections by the EU. But you have to do these individualized country assessments to determine whether your data transfers provided essentially equivalent privacy protection. So basically, you had to do this assessment of receiving country law enforcement and national security surveillance laws to determine whether they unduly infringed on European rights. And so the permissibility of this transferred personal data on the basis of standard contractual clauses will depend on the results of your assessment. And it's really a fact-based assessment. And they didn't give a ton of guidance right away. So it's something where companies were left to their devices, at least initially, to look at their technical, administrative, and contractual measures that applied to how they handled and disclosed European personal information to government authorities to perhaps make this argument that, yes, we can still comply with the requirements of European law. And just one quote to throw up there. This is actually a quote from the European Data Protection Board, which is a group comprised primarily of the head privacy regulators in Europe that issued an opinion interpreting the court's decision right afterwards. And I won't read the whole thing, but this really drives home at the end. If you take a look to say you have to do this case-by-case assessment, you have to put in place these supplementary measures to the standard contractual clauses. You can't just rely on the standard contractual clauses anymore if your assessment of the receiving law indicates that the law is not sufficient from a European perspective. And newsflash, the US law was not considered sufficient by the court itself. So which means that everyone evaluating transfers or trying to continue to do business to transfer data to the US, pretty much most companies were operating under these standard contractual clauses, and you had to do this case-by-case assessment to take into account the circumstances of the transfers and possible supplementary measures. And you can see at the end, if you didn't conclude that you had sufficient supplementary protections in place, you had to suspend or end the transfers of personal data. And that takes us to where we are today, where there's a obligation or responsibility of companies that if you don't think you can meet the standard, you can no longer engage in these transfers, which has led to a lot of confusion in the market. So we'll turn it over at this point.
Thank you so much, Brett. You did a wonderful job with the summary of this very, very complicated and complex matter. And at this point of the presentation, we want to highlight why is this relevant to you? Why is this relevant to literally all businesses that actually do business in Europe, transfer data of personal data of individuals from Europe to the US? Well, earlier this year, the Future of Privacy Forum published an infographic that actually shows the complexity of even the most mundane operation of a day-to-day life of a modern person. So we actually looked at two scenarios, one of them being the retail data ecosystem. And we took the example of an online purchase, right? So just purchasing something from an online shop. And then we also look at a scenario very much used, particularly in the past year and a half, online learning. I'm not going to talk about the second one, You can find it in the infographic, and I'll be happy to share a link in the chat. But when we're looking at the retail data ecosystem, the amount of data flows it is just staggering, because you have to take into account we are not only talking about the simple act of purchasing and sharing your contact information, but also we are talking about an individual making that purchase with a credit card at this particular merchant. Then we need to take into account authentication checking before the payment is authorized, whereby the card issuer has a role, right? Because they need to authenticate that the card is the card belongs to the person that actually makes the purchase. Then we also have an authorization processing going on for that transaction from the cardholder's bank. That needs to play a role in this too, and that also requires personal data. We have the facilitating of the routing of the payment and all the actors involved there. There's also global fraud detection. And then think about all these actors possibly being situated in different jurisdictions, and all of this data needing to flow between jurisdictions for a very simple act, a very simple transaction, if you get to think about it. So the fact of international data transfers actually touches upon most of the current economic and other type of interactions online, or that rely on cloud-based services. If you can go to the next slide, please. One point that I would like to be very clear about is that the European data protection authorities consider simple access to personal data of European data subjects in a cloud as a form of transfer. This means that even if all of your operations and staff are actually located in the US, if you access data of individuals that are located in the European Union, that is going to be considered from a legal point of view a transfer of personal data. So this is why this entire debate has such wide-ranging implications. And then to give you other examples from the day-to-day life that are impacted by these requirements and by this new reality of international data transfers. Think of the global collaboration to combat the COVID-19 pandemic. When those large-scale clinical trials were set up, with actually collaborations from many countries, there was a real question and an assessment needed to be done on what are the lawful grounds that permit the data of patients in Europe to be transferred to those conducting clinical trials, perhaps based in the US. There's also the example of customer service operations that I'm sure is very familiar to many of you listening to us right now. And we know that such customer support systems are implemented by many organizations. And we also know that they actually need access to data from the cloud. And as I was saying, the mere access actually counts as an international data transfer. Alexandra?
The next slide, I think. Yes, Smith and this. So we've talked a little bit about the legal background for this and why it matters to global companies. So just to touch on a couple things. When companies are setting up their infrastructure and we're trying to do this in the most efficient way, we look at global sourcing. So we're looking at how we can, as Gabriela mentioned, set up customer service centers that might support the entire enterprise. So if you have a global company with customers and employees worldwide, you likely have customer service hubs in certain jurisdictions that provide services to all of your customers. You don't have a customer service center in every country or jurisdiction where you operate. That just would be costly and inefficient. So when we think about the kind of the backdrop of this from a practical perspective for companies that are trying to follow the cases and follow the kind of the political wrangling that's happening with the potential renegotiation of Privacy Shield, we're looking at ways that we can operate on a day-to-day basis. And one of the things that I'm sure some of you on the call will resonate with is these myths and misconceptions of how onward data transfers work and what are some potential solutions. So in the absence of a political solutions, in the absence of a Privacy Shield 3.0, or if your company decides not to implement supplemental measures or not to do those transfer impact assessments, or if your customers are not satisfied with the legal mechanisms that you are in fact putting in place, what are some of your options? So you may be getting questions from your internal business stakeholders in sales or some of your European colleagues asking questions about, well, why don't we just build a data center in Europe? Or why can't we host our authentication center in Europe? And the reason that that's difficult is because of the very broad definition of processing under the GDPR, which Gabriela spoke to in her example and her infographic. So any type of collection, use, access, storage is processing. So global companies that are working with an architecture and a tech stack that's likely global and not siloed country by country have a very difficult challenge ahead if there is no political solution and if the legal uncertainties aren't sorted out. So building a data center in Europe, for example, think about what type of data you would be potentially hosting in Europe. Would it just be customer data and content, project files, for example, that your customers might be storing in your SaaS solution? Or are you talking about every single piece of personal data that must be collected and stored, processed, and accessed only in France, for example? If that were to be the case, a company would likely have to re-architect its entire infrastructure, have dedicated vendors that only work in France, because if you have a customer service center in Texas, that customer service center would not be able to access the French data that's hosted in France if you're going to truly have a dedicated personal data processing and storage data center in Europe. The same thing with authentication. If you think about security controls and how we run most security programs, there's benefits from seeing global trends and diagnostics. And if you're only capturing security vulnerabilities in one jurisdiction in which you operate, you're potentially not seeing the whole picture of the threats to your organization. So that's another myth and misconception that we're concerned about in terms of resolving some of the chaos and uncertainty that we see currently with the political and legal underpinnings in the reality of what we're facing today. I also want to mention one company that has taken a kind of bold stance. Microsoft earlier this month made a statement from Brad Smith that they would be pursuing a data center option in Europe. And in their statement, which was geared towards, in my opinion, kind of a PR customer demand perspective in terms of seeing this legal uncertainty that we see out there, but also, customer sensitivities that Brett spoke about in terms of government access to data, a lot of the, tech lash and mistrust of companies. They're acknowledging that, and they've reported that they will be pursuing solutions and offerings for their Azure and 360 products, their commercial products, to have all data stored in Europe. Now, the devil's in the details, and they said that they'll be working on this for the next, year or two to figure out, what exactly is the offering, and if, technically all data is in fact stored in Europe, or some of it still comes back to the US for some storage and processing. But I think this really is an interesting development where we're seeing a very large company take this sort of bold move in going beyond what's legally required and attempting to satisfy customer demand in this area. It'll be interesting to see the follow-on effect if companies like AWS or other companies start approaching this in a similar way and offering additional types of local data processing in Europe beyond what's legally required.
So Alexandra, we got a question in the chat that's on point here that came in before this slide. So it was a great question. It says, we deliver services for other companies from delivery centers across the globe. This seems to state that we have to provide all of this, even for the users in a delivery center. Is that your interpretation?
So I think you have to take a look at your data flows and figure out sort of what is that a vendor solution, or is that, you know, part of your entire company? So I think, yes, you certainly have to look at whether that's part of your enterprise and whether that would be covered under transfer, as Gabriella worked through that definition, as processing, as you see in the slide here. So just because, you know, it's not the bulk of your business, or it's an ancillary service provider or ancillary to your core service offering, it's something that you need to take into consideration. And you could, if it's a vendor, you could potentially put some contractual terms in place that would resolve that issue for you. Should we go to the next slide? So here, in terms of regulatory risk, what we're seeing here is the transfer to information without the adequate transfer mechanism. So this, again, is a challenge for companies. You know, understanding what your data flows are and where and how and to which countries you're actually transferring data, so that you can, in fact, do those transfer impact assessments. And what is it that we need to put in place in terms of these supplemental measures? And we're seeing some cases that I think Gabriella is going to speak to, where certain regulators are striking down transfers because either the company didn't have supplementary measures in place, or those supplementary measures were found inadequate. So I think in terms of regulatory risk, there is either the threat, the sensitivity that customers are raising, the uncertainty about what types of data transfers will remain to be permissible. You know, the court decision says one thing, and then what's happening in practice is sort of another thing. And then also what types of case law we see is another data point that companies need to take into account as they're evaluating how we're going to continue to offer global services for those customers that are worldwide.
If I can add here, indeed, Alexandra, on some of the cases we're seeing in practice. So what's happening is that, as Brett was mentioning at the beginning, this judgment that annulled the Privacy Shield came in July of last year. Then for many months, we have not seen regulatory action, because also data protection authorities, the European Data Protection Board, are trying to figure out, you know, how to transpose it in practice and what type of guidelines to give companies. There's already a set of draft guidelines out there for which the EDPB, the European Data Protection Board, received input, and we're not waiting to see the last version of the final version of those guidelines on supplementary measures. But what we've seen in recent months, I would say in the last 2 months or so, is that data protection authorities started to actually implement the Schrems II decision and to actually issue decisions and take regulatory action against some companies. There is one very relevant case from about 2 weeks ago from Portugal, where the Data Protection Authority of Portugal issued a decision against the National Statistical Institute, the National Institute of Statistics, that was conducting the census for the Portuguese population and was relying on data storage and some data processing with on services provided by Cloudflare, based in the US. And the Portuguese DPA actually ordered this National Institute to stop using the services of Cloudflare because there were not sufficient measures in place to ensure that the data of the entire Portuguese population was sufficiently protected against government access to data here in the US. So that was very interesting to see. There are also a couple of other cases, one that's very relevant and that might provide a bit of hope for companies trying to continue data flows is one from France, where a company, Doctolib, was actually brought into judicial proceedings by several complainants, saying that it relies on the services of AWS and that it stores very sensitive data with AWS because this was about data on vaccination scheduling of the French population and COVID-19 vaccination scheduling. However, the court, at least in first instance, said that the safeguards put in place by AWS on top of the standard contractual clauses, the technical safeguards were actually sufficient to ensure that the transfer to the US, if a transfer occurred, was actually lawful under the Schrems II criteria. Brett, for the next slide, please.
Sure. I mean, the interesting thing here is you're hearing names that are very familiar to you: AWS, Cloudflare, Microsoft. This is not just, transfers to your affiliates or smaller vendors. This is every cloud infrastructure that you use. And some of the big players are thinking about this a bit more, but that's just one of the reasons why there are so many implications from this ruling. You can see on the slide here in terms of the stakes, right? We're talking about the full potential scope of GDPR fines, which is 20 million euros or 4% of worldwide annual revenue. We're ordering the suspension of data transfers, which is what was bandied about in the Portuguese case. So this is real impact. Maybe there's some helpfulness that everyone's in a similar boat at this point, but someone has to be the first one off the boat, I suppose. And so there's a lot of hand wringing about. Hopefully, it's not your company first, and hopefully we come to a solution before that. But maybe some light at the end of the tunnel, as we'll get to. And just as a signal to some of the regulatory risk before some of these cases that Gabriela mentioned, here is a quote from the Berlin DPA. So in Germany, each of the German states has their own DPA, Data Protection Authority. They said something very foreboding right after the Schrems case came down. The times when personal data could be transferred to the USA for convenience or cost savings are over after this verdict. It is now the hour of Europe's digital independence. And you might be reading into that some sort of local protectionism or support of local industry, and I would posit that that's probably a factor in some of this as well, even though it's obviously not part of the legal case. There are certainly some of those who are seizing on this as a benefit for local industry, and so you have not only legal factors but political and economic factors in the swirl as well. One other thing that I wanted to mention is business partner requests. Some of you may have been dealing with these. So after this decision, if you recall, this decision requires you to undertake a case-by-case assessment of all of your data transfers outside to vendors who are located, or to third parties who are not located in Europe or another adequate jurisdiction. And so what this means is you actually have to do an assessment. And in order to comply with this standard, in the court opinion, which was far from clear, you had a wide variety of approaches. So many of you may have dealt with this, getting questionnaires or requests from your customers, your service providers, even affiliates, asking how you're handling personal information and what laws your handling of personal data are subject to, which in complex countries like the United States, there's many potential laws that you might be subject to, where you might be compelled to turn information over to the United States government, and subject to, and what due process protections are in place, and are those essentially equivalent, if you go back to the standard that we talked about before, to protections in Europe. And that's, not a trivial exercise, but this is what's been happening over the course of the past year. And what we've been advising clients is, look, your obligation under this opinion is to do this assessment. We don't know the form, the court did not specify the exact form of assessment that needs to be done. But if you don't do this assessment, then you're clearly in violation of the standard. So you need to do an assessment. Here's our thoughts on how this assessment should go, but you should at least ask some questions. It's obviously a little more of it goes into it than that. But as a result, you got a lot of questionnaires and a lot of requests for how are you handling information that are subject to the GDPR. And this, I have seen it has included delayed deals and lost business. And I'm sure some of you have seen this too, where privacy questions are the ones that keep the negotiation going, or are the ones that where someone might say, I'm going to go with this European vendor instead of you, American-based company. And so there's real world impacts to this. So you get these diligence requests. And as an example, we have here, so Max Schrems, in addition to in bringing these court cases, has set up a non-governmental organization where he has created, among other things, a model request to send to your service providers and other third parties to assess their compliance with the opinion, and it's quite strict. And so we have seen this one get sent around by a number of businesses who said, hey, great, this was already written, and this is how I do my assessment, and they've sent it out, and it's quite difficult to answer those questions in that assessment. So that's just one example of it, and you may have seen this. It comes from his NGO called NOYB, which is short for None of Your Business. At the end of the day, these requests can be difficult to answer, and you have to do some sort of assessment. Let's say you're a US-based company. You're asked about what is the ability of the US government to access your information. Are you subject to a potential order under the Foreign Intelligence Surveillance Act, Section 702, which requires it's a non-trivial legal analysis actually determine whether you're a covered electronic communication service provider. And these are adding costs to doing business in the post-Schrems age.
Brett, can I add just a couple kind of
please
practical considerations for companies that are dealing with this, because that's part of my job. So, the standard questionnaires that we're starting to see. So yes, they are challenging to answer and find the content, but I think it's also just think about the administration and sort of the internal communication and the process by which you're responding to these requests. So if you have a dedicated privacy program, legal team that's working on these, make sure you have consistent responses and you have a process for intake and review of these and responding within the adequate time period and so forth, so that you don't have, that you're not causing more legal problems for yourself potentially, or for your sales organization by not responding adequately or in a timely fashion, or by having, confusion or inconsistent statements. So have a plan, have a standard set of responses and an intake process by which you can manage these requests that are coming in.
Well, that's a good segue into practical ways forward. So why don't you continue?
Sure. Yeah. So a couple of other things, just from the in-house perspective that I can bring. So I think, and a lot of this is basic block and tackling that we all need to do for development of a privacy program. And it definitely comes into play with onward data transfer and data localization issues. So, understanding your data transfer. So, what are your data flows? Like, to which countries are you transferring data? What vendors are you using? Understanding sort of how you're operating as a business, so that you can make some decisions about where you're going to conduct those transfer impact assessments. Are you going to do it on all countries? Or are you going to try to prioritize high-risk countries where you have more of a presence? Those are all things that you can take into account. What are these additional safeguards that you can put in place? So the court decision has some information. I've actually found benchmarking to be much more useful. So looking at what companies have publicly acknowledged or posted in their data processing agreement or other privacy materials that are their supplementary measures, and making some considerations about what works for you, what level of encryption, what level of security standards, whether you have a transparency report, whether you have a policy of how you respond to government access requests for data, and how aggressively you might resist or fight those, or how you deal with those when they come in. So taking into account what other companies in your space are offering, I think is very useful information to see, from a competitive differentiator perspective, what is it that you might consider offering and what's possible for you to offer, because some of these additional security safeguards, require some development or some choices about how you're offering your services and your systems. I think I spoke a little bit about this in terms of kind of your communication protocols and FAQs and how you're messaging, standard. There's sort of the internal communication to make sure that there's consistency among your legal team, among your privacy team, among your security team, and among your sales team, how you're responding and what is sort of the company's line and statement on some of these questions. And then externally, what are you saying on your trust center, for example? What are you posting if you make your data protection agreement public? And then how are you responding to customer requests, either through an RFI process or escalation and negotiation of your customer deals? Having some standard set of responses helps from a consistency point of view, but also just administrative efficiency. So you're not sort of always creating the wheel and recreating the wheel and always sort of in a, last minute fire drill to run down a response to a customer question. So this onward data transfer uncertainty has created a lot of extra work for companies. I'll be perfectly honest, since last summer, there's been a lot of work to shore up some of our contracts, some of our security protocols. There are some things that are within the company's control, some things that we can do, making sure we have these safeguards in place, contractual provisions in place, communication plans in place. But many of us are waiting for a political solution, Privacy Shield 3.0, to take some of the burden off of the companies, so that we have, the standard political solutions, so we can continue to transfer data out of Europe to maintain our business. So in terms of the legal safeguards, contractual provisions looking at the non-EU government authority access to personal data. So these are controls that you can put in place in terms of, just general access controls to your data. But what are you thinking about in terms of policies for government requests for data? Do you have a transparency report? Do you require a subpoena? Things like that. Again, you can look at some of the benchmarking of companies that publish these. I think it's also very important to consider, how aggressively you want to resist or fight these requests, and also what are the requests or the access to data that companies just don't know about, because the government may or may not be accessing data without asking for the company's permission. And then, what other types of contractual provisions can you put in place? And also thinking about those downstream contractual terms with your vendors. So the contractual terms that you have in place with your customers, but how are you replicating that into the privacy and security obligations that you put in place with your vendors, that sort of pass through downstream due diligence of your vendor base to make sure that they are in fact including some sort of supplementary measures, if you, the enterprise company, are putting those in your contractual commitments to customers.
I got a direct message question that's on point here too, which is, how do you know when a vendor is transferring your data, since they own the data flows and some are not open to sharing that information? How do you make sure that they're complying?
So I think that's part of your vendor management due diligence. So if you have contractual provisions in place, if you require, some responses to that as part of your vendor due diligence process, either in a security questionnaire or other discussions you have with the vendor, I mean, you're entitled to some answers from your vendors about what they're doing with your data and what security controls they have in place.
So I'm going to talk for a moment about administrative safeguards. So part and parcel with the contractual provisions that require you to take certain steps before complying with a third party or government request for information, you may want to actually put in place a policy that clearly describes how you're going to respond to these government requests. And this policy might include the specific legal bases that compel or allow the disclosure of information, so you and your team know when something is required by law, or are able to assess it before releasing the information, as opposed to perhaps a non-mandatory request for information where you might not automatically disclose it, and the conditions that have to be met in order to make a disclosure. Put in place a process, for example, on who will be responsible for implementing this. For example, is it going to be your litigation team? Do you have a special department for handling government requests if you get a number of these? One of the subtexts of this is the forthcoming standard contractual clauses. So the standard contractual clauses we talked about, there's two forms of them depending on whether you're transferring to a controller or processor currently, and the last versions of those were adopted in 2010 and 2004. And so they really didn't take into account they didn't take into account the Schrems II decision. They didn't even take into account the GDPR. And so these have been under process for revision for a while. And drafts of them were published in November. The European Commission took comments, and they're going to, we hear any day now, a matter of weeks, couple months, sometimes the wheels of the European bureaucracy move slowly. But we know at some point there's going to be an updated set of standard contractual clauses that are going to be rolled out with likely a 1-year grace period for implementation, which will kick off another contracting exercise. But one of the features of these is there's a whole section on all of this about how a recipient outside of Europe has to, or subject to the standard contractual clauses, has to push back on government requests. So you're going to have to put in place, if you're going to comply with them, this type of process eventually. So it's probably worth starting to have those discussions. A second administrative safeguard or a process to put in place is publication of transparency reports about the scope and extent of the provision of personal data to public authorities. And this can serve a couple of purposes. One of them is just being transparent. So European regulators, your customers, know exactly what types of requests you're getting. Sunlight is the best disinfectant. They can see how things are going. But also, if you're one of the companies that's fortunate not to get too many national security requests for information, this can also be a pretty good signal that you're not a high risk recipient of information. And Alexandra, I know you have some thoughts on transparency reports.
To echo what you just said, yes, I think putting the process in place to make sure you have a dedicated team that's reviewing these, and you've aligned on what is your process for reviewing and what's your criteria and how aggressively are you going to review them, subject to all the legal requirements and the benchmarking that you may have conducted. But I do think, the range of transparency reports out there is interesting to take a look at, because there are certain companies that get hundreds of these a year and they report them in their transparency report. There's some companies that get 0 to 1 or 2 of these a year. So there are certain social media companies or email providers that, have more data of interest apparently to government requests than other companies. So if you are one of the, as Brett said, the potentially lucky companies that are getting few of these, you could potentially use that in your sales negotiation, that, you are potentially less at risk and your data is safe and secure. You have all of these other security protocols in place. So there's less potential concern that a European customer may have with dealing with you and having their data stored and processed in the US.
So going back to the slide, we have been talking a lot about supplementary measures and also about technical supplementary measures. And a quick note here that even after the European Commission publishes this new set of standard contractual clauses, you will still need to actually put in place additional supplementary measures. Some of them are of the legal nature, some of them are of administrative nature, as Brett and Alexandra were saying, but a key type of supplementary measures are technical measures. The EDPB published the draft guidelines, as I was mentioning before, and in those draft guidelines on supplementary measures, you will see already a number of specific use cases for specific types of technology that can be used. And I would say, they don't actually leave a lot of scope for moving forward with a lot of the transfers. Just to give you a flavor of it, when we're talking about encryption is considered in detail in these guidelines. And indeed, the EDPB says that encryption works for data storage, for backup and other purposes that do not require access to data in the clear. It also works for encrypted data merely transiting third countries and transferring data to protected recipients, such as lawyers or doctors, just in those very specific cases. However, encryption does not generally work for transfers to cloud service providers or other processors which require access to data in the clear. And it also does not work for remote access to data for business purposes. And we already talked a lot about this remote access scenario. The EDPB also looks at pseudonymization as a potential technical measure to put in place. And indeed, pseudonymization can also be used. It could work in general. When I say pseudonymization, think of key coding data. And there's a lot about keeping the key within Europe, that, ensuring somehow that access to the key is not easy, and keeping it perhaps with an European entity so that it escapes the US Cloud Act. There's a lot of debate around that. However, also for pseudonymization, as you can imagine, there are big caveats of when it can be used and when it cannot be used. Other type of measure that the EDPB is considering is multi-party computation, which again could work in some scenarios, but there are caveats there as well. And all of these scenarios are actually described in quite a bit of a detail in the guidelines. I would say that it was precisely those recommendations for supplementary measures that made all of us think in the end a political solution is the one that will solve all this, because businesses can do what they can do on their side, but in the end a political agreement is needed. And there's perhaps a need to push the Department of Commerce a bit, to push a bit your representatives in Congress to take action on some of the political measures that are needed.
I would echo that as well, Gabrielle, and just to add one other point. I think the security and technical measures in a lot of cases track what companies already have in place with their security program and track some of the requirements for SOC 2 and other security certifications. Some of those are so strict and so unworkable as to really prevent companies from providing the services, because they need access to unencrypted data, or they need to have some of these are preventative from actually being able to access the data in a way that's workable. So I think that's sort of the tension that we're seeing, is the intent behind the safeguards makes sense, but I think sometimes the way that they're drafted isn't very practical in terms of what works for companies on the ground.
So we already talked about responding to diligence requests. You need to respond to this type of requests, and Brett and Alexandra already gave you a lot of guidance on this particular question. I would say I cannot emphasize enough how important it is not only to do your due diligence, as it was highlighted already, but also to have those standard contractual clauses in place. And to give you another example from a case earlier this year from Spain, the Spanish Data Protection Authority sanctioned Vodafone for a transfer of data not to the US, but to, it was either Peru or Chile, one of the two countries in South America. One of these two countries, I can't remember correctly, but the Vodafone actually did not have any safeguard in place. And that was the ground for issuing a fine immediately. You know, there was actually no room to argue that, look, we have something in, we have contractual safeguards, and we also thought about these additional measures. All of these are mitigating factors in this type of decisions. And perhaps the last slide. Here we were supposed to, each of us, to say a type of concluding remark. I think I already ended mine. Have something in place, as I was saying. And if there's one of the things that you can do from my point of view as a policy person, really push your congressperson, knock at their door, give them a call and say, look, this is a serious problem. We are losing business because of this, and we need a political solution. We need some changes in the law, engage with your partners in Europe and find a solution to this.
And my final takeaway would be, make sure you're clear about what is your approach to manage the legal uncertainty, and what are you doing in response to your legal mechanisms for data transfer, but also recognizing that with Microsoft and other companies that are starting to offer data localization solutions, that the ground is shifting and competitive pressure may change what companies are expected to offer above and beyond these legal requirements.
So with that, we have a couple minutes left. Maybe I'll pose a couple questions. We had actually a really good question. Gabriella, I'll pose it to you. What about companies who have binding corporate rules as an alternative to standard contractual clauses? Are they required to undertake this assessment under Schrems too?
Yes, they are also required to take this, to undertake this assessment, and the EDPB was quite clear that their supplementary measures guidelines are actually applicable across the safeguards in Article 46 of the GDPR, which includes BCRs, includes codes of conduct, even though I don't think we'll soon going to see a code of conduct for transfers, unfortunately, because it's such a burdensome and bureaucratic process to get one adopted. So this assessment will be needed for BCRs as well, but I would dare say you are in a bit of a better place, given that you already obtained an approval from your lead DPA for the BCRs.
Alexandra, one last question for you. If there's a vendor who wants to analyze users' emails in order to provide email writing suggestions, and they say they discard sensitive personal information, but ultimately it depends on how they design their application, does that cover them from not having to deal with cover you from not having to deal with any of this with respect to this vendor? Or is that a data transfer, a data access point where you have to go through your vendor diligence process and making sure everything works?
So I think it depends on what type of data the vendor has access to. If it's non-personal data that they're using for their analysis, it might be out of scope, but I would argue you still want to have some sort of contract in place with that vendor to manage some of the other legal issues. But if there is personal data at play, then I think most companies would require a security review, some sort of contractual terms related to privacy, and you would want to make sure that you had those sort of downstream controls in place, related to onward data transfer. So it depends on what that vendor has access to, the data elements, and whether that's personal data or not would be my initial take.
So I think we're at time. Thank you, everyone, for joining us today. And we hope to talk to you about this topic again.
Goodbye, everyone.